Welcome, everyone, and thank you for joining us today for Navigate Home as we continue to provide our passion of helping seniors with resources and information that we can provide. And so today, what I would like to really talk about is my name is Mike Rutkowski with the Rutkowski Law Firm. We specialize in estate planning and elder law. And so often people might set up an estate plan that requires some administration after a loved one has passed away. So I'd like to take a minute today to talk about trust administration. And the reason I want to do this is because so often I think it gets overlooked in some of the responsibilities that you might be putting on a loved one when appointing them as your trustee in a document, as your executor, as your personal representative. So I'd like just to take a minute today to talk about what that looks like. And also at the end of this, I'd like to provide some guidance on how we can help, and we can help people that you have appointed in your estate planning documents. But let's just hypothetically say that you've put in place an estate plan. Estate plans usually include a will, a trust. These are the documents that really talk about the distribution of assets after someone has passed away. And so a lot of times the goal of a family that we're working with is to avoid the probate process. Probate, at least here in Michigan, can be relatively expensive. It can be time consuming, especially during a time where like this pandemic, where we don't have access to the courts as we regularly did in the past. It's a little bit more challenging to get court hearings scheduled and get in front of a judge. Assets can be tied up and frozen for quite some time. So, the trust might have provisions in there to distribute assets to a spouse or to kids. And so let's talk about what that looks like once a loved one passes away. Typically in a revocable living trust, which is most of the trusts that people have, they would appoint someone as a trustee to manage the trust. Now, usually the person who created it, or the grantor, which is just a fancy name for the individual who created the trust, they typically act as their own trustee during their lifetime. So they have the ability to not only make changes to the trust, but control the assets within it. So if you have a retirement account, a house, something like that is tied to the trust, the trustee, the person who set up the trust, has complete control. But let's talk about what happens if something were to happen to that original person who set it up. And this could be anything from a health condition that is causing incapacity. It could be an unexpected event like a car accident where the person can no longer make decisions for themselves. Or it could be eventually, just as the aging process goes, eventually someone might pass away, and now someone else has to deal with these assets, control these assets, and do something with them. And so that would be your successor trustee. This is the person you've named in your documents. You might have a couple people working together, but it all ends up being the same responsibilities. So this now successor trustee has to manage those assets while the person is alive, and if they pass away, there's things that need to happen. And I'll go into some of the basics of some of the things that need to happen, but I also want to mention that we do constantly, once a quarter, hold a trustee training workshop where we just, at no obligation to anyone, just provide information of what is expected of you as a successor trustee. So feel free to share this video with anyone you might have appointed in your documents. It's whether you worked with our firm or not. Maybe you're working with a financial advisor, or you are a financial advisor and you have clients that could benefit from this. This is just an open to the public. You don't have to be a client or family member of ours at the firm. But let's just let's talk about, fast forward and what happens if someone were to pass away. A lot of times people think it's as simple as, okay, it's equally to the kids. I'm just going to consolidate the assets and write checks. And sometimes I wish it was that simple, but there are things that need to be happening. There's things that you need to do as the successor trustee. At first, there's going to be some last known expenses or debts that might be part of the estate. Maybe there was a medical condition that towards the end, there's going to be some medical bills. Maybe there's a car that was leased that needs to be turned in. There's going to be assets that need to be dealt with. And so you as successor trustee have the responsibility of doing these things. And so first and foremost, the thing that we want to do for any family that we work with is we publish something called the notice to creditors. And essentially what that does is it opens a window of time for anyone who has a claim on the estate to come forward and say, I am owed money for these services. I am a creditor of the state for X, Y, or Z reason. And it is the successor trustee's job to either pay off the debt, disallow the debt, or do something with it, if pay it off if it is legitimate. And so what we want to do is we want to open that window as soon as possible to make the window as short as possible, typically 4 months of time where at the end of that 4 months, we now know we're in the clear. We now know that we can liquidate the estate because all debts have been paid. So now we know what the estate truly looks like. So opening and closing that window where creditors can come forward is extremely important. We do not want to just immediately after someone passes away start distributing all the assets, because if there are some legitimate bills, they need to be paid out of the estate. And we hope we didn't already give that money away to a child beneficiary or someone else who can't give it back. And so this could become problematic for the trustee. And as we guide families and successor trustees through this process, something we definitely always want to be mindful of is we want to create no personal liability for the trustee. I mean, the trustee is just doing a favor of the estate to take care of all these things. Typically, a trust might provide for reasonable compensation, but that successor trustee is not typically doing this to make a bunch of money. Usually it's a family member that might not be even getting paid for the services that they're doing. So we really want to protect that successor trustee and make sure that there is no personal liability there. So that's one of the important things that I think gets overlooked a lot when just an individual goes through the motions of acting as successor trustee. We want to shut that window down so no one in the future can come forward and make a claim on the estate. There's also tax filings that need to be done. It all needs to be done within a certain window. We all know how strict the IRS can be, and we don't want any penalties or anything like that. So there's a certain window for that. So there is a lot more complication over the administration of a trust than one might think. A lot of times trusts might distribute assets over time instead of all at once. And that might require an ongoing trust administration where you might be paying out, let's say there's some minor kids that are 10 and 12 that the trust doesn't liquidate till they're 25. Well, that's 15 years of, constantly making sure we're taking care of those beneficiaries. So it can get overly complicated. I would just recommend, if you are a successor trustee, attend our webinar. Now's probably a good time to give that information. So it's on May 4th at 5 o'clock. So it's on Tuesday, May 4th, 5 to 6 o'clock. We will give a presentation of information. It's all educational based. I will open it to questions also where we can engage with anyone who's participating in it. And again, we do this quarterly. So if you can't make this one, feel free to reach out to us to get scheduled for the next one. But so if this is something that interests you, or maybe you could share it with someone who it might be of interest to, just reach out to our law firm, rutkowskilawfirm.com, RUTKOWSKI lawfirm.com, or call us at the office 248-792-9193. We'd be happy to help share the information. It just makes that process quite a bit easier. Thank you for having me today. Again, I hope I shed some good light on what it looks like for trust administration. Sometimes it's not as easy as one might think, but we're here as a resource. If anyone has questions, you can reach out to us, social media, our website, whatever makes the most sense. Have a great day, everyone. Thanks again, Navigate Home, for having me.